a great story. Probably absolutely one of the first customers I ever started banking. He came to me. His request was an extremely small business loan. It really wasn't, anything larger than a car loan, but it has grown over the 8 years that I've been here. He has thoroughly succeeded and has become one of the best customers of the bank. He's loyal. He refers business to me every day, every chance that he gets, and that's cool.
We've got a somewhat lengthy agenda, and in the spirit of the day, we'll begin with some PID budgets here in a moment. Let's run through the agenda. We'll come back and have a discussion relative to some of the work that's gone on prior on potential charter amendments, and then we will need a closed session, ample time to prepare for the meeting tonight. Item number 1, consideration of the minutes from last week's meeting. No other comments, questions?
I wasn't here, so it's up to you.
Okay, Kathleen Collins is here, and she is going to take us through item 2, 3, 4, and 5. These being the first 4 of your public improvement district budgets to come before you. And there are, I think, 5 more that will come next week, 4 more that will come next week, and then we'll have the PIDs done. As you're reviewing these today, that means when we get to that section of the big budget book, we won't have to backtrack and go back through those. So if you'll turn to tab 2 and turn past that ordinance, you'll see the service plan and the budget, and we'll have Kathleen start us off with the colonies.
Okay, thank you. The colonies is located between 45th, Hillside, Sauncey, and Coulter, and it has improvements that include a clock tower, bridge house, fountain, and multiple pocket parks. Their assessment method is based on the square footage of platted lots, and this subdivision is approximately 75% platted with 610 residential lots. The PID board met and reviewed the budget and the service plan, and their projected beginning fund balance is going to be approximately $4,917 for 2013-2014. They're expected to spend approximately $430,000, $132 for their maintenance and operations, as well as their administrative and debt service. And we're anticipating their total assessments to be $509,255. That's due to the increase in square footage. The developer had platted almost 1 million square feet this last year, so that assessment number has increased from the previous year. The PID board recommended to keep property assessments at 7 cents per square foot, and this is to increase their operating reserve and to maintain a positive ending fund balance.
Kathleen, are you appointed to look over all the PIDs now? Is that your?
Well, Clint with Parks is also reviewing portions of what the park maintenance does, and then also Laura Hastings with accounting is also doing this. So we're collectively looking at this together and making sure that we have enough of a balance here.
Last year, maybe it was the year before last, some people, and I'm not saying it was in the colonies, but some people in PIDs acted as if this was the first time they had heard how much their assessment was going to be. Do we have any way as a city of making sure that all the homeowners that are in a PID are contacted, or is that any of our business?
We do. We recommend that the PID advisory board get with their homeowners association and discuss that. Now, we have some homeowners associations and PID boards that are more active than others, and then some, we have some that are smaller PID areas, so it's a lot easier to contact all of those board members and all of those homeowners, and so there may be some more. Right.
Yeah. So it's not really that, even though we recommend that, it's not really the city's job to make that happen.
It's a pass through with an administrative.
exactly.
And by state law, we
publish
do-
the notices.
Right, and by state law, we do have to notify each property owner within the public improvement district, and that's done approximately 10 days before your group meets.
But that's with a public notice, it's not individually? Or is it individual?
It's individually,
Okay.
yes, each homeowner receives a statement or a notice.
A blanket question about all these bids. Have there been any citizens who have mistakenly thought this year that this was something that the city was doing to them?
Not so far.
Because that has been the case in the past.
Okay.
Yeah.
I have not heard of that yet.
Okay.
Can I point out one thing? In your 5-year plan, your proposed budget for 13-14, Kathleen went over the totals with you. We've actually included a bond issue of $1.5 million to do a developer reimbursement to the Colonies developer. Last year, they raised the rates from 5.25 to 7 cents in anticipation of doing a developer reimbursement. So they will have sufficient revenue to be able to afford to do another bond issue.
Okay, thank you.
And the PID board has the authority to make that decision?
No,
Homeowners.
it would be the PID board, but the commission would have final authority on it.
You still have to go to voting up.
But
Yes.
We have to-
Yes, sir.
And just those homeowners will pay for the.
Yes.
Right, that's only assessed to the Colonies PID homeowners.
Every PID is designed to be completely 100% self-supporting. Those persons living in that area self-assess. It's brought forward as a recommendation for you to look at and make sure they're not biting off more than they can chew. Make sure it's not going to somehow come back on the city. And when all those boxes are checked off and it gets assessed, that money that they take out of their pocket and put in supports these PID programs. And by statute, they have to have a 5-year rolling plan to keep those programs current, relevant. Some neighborhoods won't, some neighborhoods don't.
It is, at least under Texas laws, it is one of the best, if not the best mechanisms to allow for these additional improvements that are above and beyond what the city will install. And it is and should be self-governance at its closest level. Questions on the Colonies? Hearing none, then let us move directly to the next one. The next one being Point West Public Improvement District, item number 3. You have the same attachments, sketch, a budget, and then the 5-year plan.
Okay. This public improvement district is located within the medical district. It's north of Amarillo Boulevard and west of Research. Its features include an entry sign, trees, grass, and those amenities are located within Wallace Boulevard and Point West Business Parkway. Their method of assessment is to divide the total expenses by the total square footage of property owned within this public improvement district. And the developer plans to extend Research to Evans at some point in the near future. However, there will be no PID improvements within that area. And so the PID board met and they have looked at their service plan and budget as well. And they will begin their balance at approximately $72,012, and their operation of maintenance and their administrative fees are going to be approximately $29,248. Their assessments will be $52,000, so they're going to have quite a bit of a surplus this year. We really like to see this healthy ending fund balance, and their PID advisory board also recommended to keep their assessments at $52,000 in order to continue to grow their 3-month operating reserve and also their ending fund balance.
Their square footage is all over the place.
Sorry?
Please.
The
These are
square
businesses,
footage.
right?
Yes.
These are businesses,
This is
not
entirely a
homes.
business
Yeah.
PID.
This is for them.
Yes. And they just divide the total by the percent get you there. Questions for Point West? Item number 4, we'll move to Redstone.
Nobody there. What are you going?
Okay, this public improvement district is located south of Hollywood, west of Coulter, north of Sundown, and east of Sauncey. Their method of assessment is to base their current market value of the property, of the platted property, at the time of certification multiplied by 0.0017. The apartment complex is within this public improvement district. However, since there are no improvements for the public improvement district, the developer has requested that the assessments be waived, and the developer will be paying for the administrative fees that are associated with this year's PID.
Is that mark on the?
Yes, sir.
That's
That's
where
where the
the-
apartment boundary is.
No question.
Okay, no questions, we'll go to item 5. Item 5 being the Tutbury Public Improvement District.
Okay, Tutbury consists of 24 lots, and it's surrounded by Tutbury Court. It's near 45th and Van Winkle. And their PID features include an entry sign, landscape medians, and seasonal plantings within flower beds. Their method of assessment is to divide the 24 lots equally. And so this year, their assessments are going to be exactly the same as last year's, which is $679 per lot, Their maintenance and operations this year should be approximately $15,590, and their assessments will cover that at $16,296. So they also have a positive ending fund balance and can maintain their 3-month operating reserve. And their PID board also recommended to keep lot assessments as is.
Okay.
Good job, Dustin.
Okay, item number 6, second and final. This is the second and final of the ordinance considered last week to update the membership of your Risk Management Board. Item number 7. Second and final, changing the zoning of just under an acre. This is in Tascosa Estate. We looked at this last week. This is the 2 single-family lots on that little corner parcel there where the road turns. Chris, any changes? Questions? Comments? Mayor and Commissioner? Item number 8, second and final, also a rezoning. This is 31 acres, Randall County. This is City View. And this is moving from agricultural district to residential district 2. Chris?
There's been no changes since last reading.
Mayor, Commissioner? Moving to item number 9, second and final, changing a 4.5 acre tract of land. This is on Sauncey, immediately south of 45th Street. And this is for the new Volkswagen dealership, I believe.
No changes as well.
Item number 10, second and final reading, ordinance 7351. This is clarifying and reinforcing section R907.1 of the residential code relating to the roofing requirements. It's directly aimed at the provision of solid decking under wood shingles. Keep saying comp, it's wood. So it shakes. Questions?
Any further word or movement or whatever from that insurance company that was insisting on?
We understand they're going to have a representative here today.
And that representative will talk to,
We understand that there may be a representative here. We had a phone call from an attorney and had a conversation, explained what they were doing and why, and that attorney said he needed to go back and talk to his clients. So we'll see.
Okay.
Since I wasn't here last week, can you explain this one to me better?
You adopted the International Residential Code, which requires, and a little detail in the packet, a solid deck under a wood-shaped roof. One of the insurance companies has contended that that doesn't actually apply in the zone that Amarillo. So what's being done here is, and Marcus can probably say it better, but it's the way it's written. This clarifies your intent that that's applicable. You've adopted that code, therefore it applies.
It's very, we think, plain English. When we adopted Chapter 9 of that code, that's what it says. And you can imagine all of the insurance companies from around the United States have been in Amarillo since May the 29th, the day after the hailstorm. They've been here for weeks. We have not had any controversy with any one of them saying, well, I don't think that applies, except one national company. And because that national company covers so many homeowners in Amarillo, we felt like we needed to make it clear, abundantly clear to that company, back up the building official. He said, no, this applies just like it says on the page. And they've taken a very hyper-technical reading, and so we've come back with this ordinance to clarify your original legislative intent.
Okay.
And our local homeowners, Roofing Contractors Association understands it. They support this. It's just
Everybody understands except this one.
Well, I got one phone call about this, and then I think I called you about it.
We had one citizen appear last week concerned with this issue, and his homeowner's policy is with that one insurance company, and we suggested that he must get his own legal advice to deal with his company on his policy claim. And he asked about other insurance companies, and we said, well, you need to talk to an insurance broker if you want to find someone else to carry your homeowner's policy. Now we're going to have a representative of that company here today, I understand. So they may speak now. They may be someone that request to be recognized on this.
I think your comments, Sam, were very helpful to him, too.
Good.
Yeah.
And speaking to the contractor, my understanding is that on average, that's an additional expense of only several $100 per house.
And I would probably vary just depending on when that original roof was put up and exactly how they set the deck in place.
Square footage and all that. It's
The larger home, a couple thousand, I don't think would be out of line if you take the lath off and go back. Or go over it.
But your point is, well, it's incremental compared to the total cost. If you get a roofing estimate, this is just one piece of it.
And at least to my knowledge, this is the only real point of contention out of the entirety of the claims that are being processed in Amarillo right now, which is tremendous. You know, the code requires greater ventilation to an attic space today than was required when they were built. My roof's been done. I went right through.
Greater ventilation.
With no, in fact, the adjuster was plumbing on the roof, and you're going to have to add more of those. Okay.
They did that to mine also.
So, all in all, I'm pretty pleased that just the sheer magnitude of the work, this is the only issue that's arisen. It's puzzling, but it's as limited as it is. Maybe we'll hear more about that too.
Are they allowed to, under the new rulings, if part of the roof is damaged, to change entirely what the composition type of the roof is? Or one section, the newer section that's being replaced is a different style of roofing than the older section?
That's going to be a policy question, not a code question.
It's all over Sleepy Hollow.
Really?
Really? And those aren't just temporaries?
Put something different. That's a
No, it goes from a slate tile roof to a composition type imitation of
I
that.
hadn't heard.
On the same roof?
I thought that one was.
Wow.
Harrington and Bauman, southeast corner, hard to believe. There's a whole lot of them like that. Just really started to
In my neighborhood, you had a lot that were quickly patched after the storm, and shingles might be different colors, but
Maybe it's
they're
gonna
coming back
change.
into place.
Yeah, maybe it didn't look like it was gonna change. Anyway.
Hodgepodge.
Okay, item 11, submission of initiative and referendum petitions. The city secretary has reviewed the 2 petitions that were recently received and has determined they have sufficient valid signatures. Therefore, under the charter, she must submit them to the city commission. So under this item, that is exactly what will happen. Ms. Hibbs will bring those forth and certify to you that they do have signatures in excess of the number required. No action is required under this item. The action is on her part to forward these to you. The immediate next item is a public hearing on and final action by the city commission to either adopt or to reject those petitions. We'll talk in greater detail in closed session here in a little while, but as far as the conduct of this item, Mayor, we would ask that you call the public hearing, which you're required to do, that you have the speakers come forth, standard, name, address, which of the petitions do they desire to speak to, or both, if they choose to speak to both, their time limit, and then move through the hearing.
Will we allow people outside of our jurisdiction to comment on this? We have, so we will.
Public hearing, anybody
Sounds
can
good. Just want to know.
There's no citizenship requirement or restriction.
Thank you.
But now, isn't it, we'll have to consider these as 2 issues, correct?
You will take 2 votes at the end of the hearing.
So following the hearing, when you've run through those comments, would suggest, Mayor, that you call on staff. You can either call on myself or Mr. Norris. Legal advice to be provided. Following that, the city commission will take the 2 votes. So you will have a vote on the first petition to repeal the drainage utility and refund collected fees. Motion, vote. And then second, a motion vote on the petition to limit the annual growth in the city budget. And again, we'll give you greater detail here in just a little bit. But as far as the conduct of the item, that's how it needs to go.
And so can the same person
Sure.
move twice for 2 votes?
Sure.
Okay.
You do them sound like they're
One at a time.
consecutively.
Consecutively, yes. First, I make a motion, petition to repeal drainage utility and refund collected fees be X, Y, or Z. A second and a vote. Immediately then move to the next one.
Okay, thank you.
During the public hearings, Mayor, are you going to do what you did last time, have 4 against, so we don't, if there's, speaking to the issues?
My view on this one is that there'll be very few people that are going to be dealing with this other than the people who collected the petitions. I mean, I just can't, so I don't know if that'll be as necessary, but we certainly could, I mean, I think
Yeah,
it's
if
going to
there's
be.
a lot of people,
Yeah.
in fairness.
Question of council. If someone wants to speak, are they allowed 3 minutes on each?
So if you
Adam,
have wants to conduct
or 3 minutes total?
It's up to the mayor,
Up to
how
the
he wants
mayor.
to conduct. What will be the rule, Mayor? We'll need to be consistent with what we do.
Well, I think let's talk about 2 things so we are consistent. What the question that Lilia raised, my feeling is that last time when we had a contentious issue, we asked for a show of hands if people would comment for or against. And when we saw it was a pretty evenly divided group, we alternated. I don't see that as happening this time, so I don't know that I would do that. I might do it just to get a sense of what's there. Is that a fair evaluation of what?
Do you want them to let each person talk on each one of the resolutions? Or do you want them to handle those as a single 3-minute presentation?
3 minutes or 6 minutes?
Yeah, 3 minutes or 6
I think
minutes.
3 minutes. I mean, I think that 2 issues, let's go with 3 minutes. I think that's adequate
Turn
to
them together
express.
and you can talk to them.
And I don't know what we're gonna have. I mean, we may not have 5 people out there. We might have 500.
You may want to let one of the sponsors from the initiative committee have a few extra minutes to lay out their petitions.
As we have with other things.
Yes, let the proponent of it.
Certainly.
No more liberal time for them to lay out their case. And then the other person.
So ask them to choose a spokesman to lay out the more liberal, since we don't know who that necessarily would be.
Oh, we do. They registered the city secretary back in January, and there's 5 citizens.
One of those
One of those
5.
five.
Okay, so we'll ask them to to have one of the five have a.
Let them be the lead-off speakers, it's their petitions.
But I believe I would come up with a time that you're gonna allow,
Right.
and time and clock.
Well, I
it
think
wherever.
there it'd be reasonable to say 10 minutes.
10 minutes.
No, I mean, I think, yeah, 10 minutes.
All right.
Because they may want to comment on both of them, and we certainly have had presenters take that much time. We've had a situation in the past. I think that sounds fair.
You're the boss.
And will we be giving outside advice in the public session?
You will.
And certainly they might need 10 minutes or even more.
Yes, yes, we
That's-
will.
You know, it's input from your staff and from your council, so
Okay.
I don't believe that's a time limited deal. It's not the hearing.
It would be nice to give them adequate time so they didn't feel like they were shorted in
Absolutely.
relation to
Absolutely.
explanations.
You know, I don't see that as a
I'll
time.
deal with that, and hopefully they'll feel they're being treated fairly.
We got your back.
Mayor, there may be some temptation, where again, it's up to what you care to allow in the meeting. Our staff's recommendation is that be patient and let the general public fully, everybody that wants to speak, get up and speak. And then we will close the hearing with staff comments and legal advice. If more citizens suddenly start waving their hands and wanting to rebut, it's up to you whether you're going to allow it to become a full-fledged debate.
I don't
or whether
think
we
it-
just receive that comment and then y'all deliberate.
We haven't done debate type issues with these in the past. We've wanted to see what the petitions are and see what the potential is to put it on the ballot. I think we'll know that from the first comments and then from staff's recommendations.
And y'all can robustly deliberate as you need to.
If the commission at some point wants me to change that, ask me. But is that fair enough?
Yes.
But I think, I mean, this is kind of an unusual deal. We haven't
Yeah, we've
dealt with
been
it
here
directly before. But I think it's, so I'm going to open it, ask for someone of the 5 signers to give comments. Ask them if it's fair to go for 10 minutes, and then we'll ask for those to speak for or against for 3 minutes. And then we'll open it up to the staff and the legal counsel. And I'm going to ask Marcus to begin that, if I can. And then we'll hear what the limits are. You know, we've already had some correspondence about this with Mr. Morrison. And so we are aware, I mean, that's really a public document.
It is.
We are aware that there are some questions on both sides, and I want to know what those are before I take action. Fair enough?
But the public comment is limited to that first section.
You mean the final public
No,
comment?
yeah, total public comments is.
Under item 12, Mayor.
Yeah, under final, yeah, that's fine.
And then once you've allowed them their 10 minutes for the spokesperson, and then 3 minutes for anybody else that wants to speak.
You know, this isn't something we do commonly, so we certainly will explain it to the whole audience of what our intention is and how this will go.
Well, but then once we get legal
We will
counsel,
explain that to the whole audience in the beginning.
you're not going to take any public comment after that.
We will explain that to the whole audience in the beginning. You know, as we said, no, we've heard both sides at that point to make a decision. Okay?
Super.
We just want to be fair about how we approach it and get all the input that we should. Okay? Okay, so we move on to consent agenda.
Consent agenda, consent item A, fire station exhaust system installation and modification. Big long-term for converting some of our exhaust evacuation systems to accommodate the left-sided exhaust on the dirt trucks.
Just get a longer pipe.
Well, that's kind of sort of what it is.
Yeah.
Of course, there's a fan that goes with it to suck it out, but that's what that is.
Yeah.
Well, it's a knockoff, they drive off with it connected, it just comes loose. They don't have, on purpose, they don't have to stop and mess with it.
I did that once with the gas plant. Not a good idea.
Well, if we did that, I don't know that we'd admit it, but thankfully, gas pump and fire station are hidden where nobody can see what we're doing or not doing with them. Item B, brush chip site lease agreement. This is an agreement for the site up on Broadway. Continuing to be provided by Mr. Chapman.
At no charge?
At no charge.
Might be a new owner, 30 days on that.
Item C, dedication acceptance public utility easement. This is associated with the continued redevelopment over at St. Stephen and
And she
And then you've got item D, your sheriff's sale property in Potter County. And we're continuing actually the group you've seen before. So,
I'm just really curious later when that's finished, what would be left of that development? It won't be
yeah,
touched.
and this one's not that development. This is up in Potter County. Questions on the action items on today's agenda?
Ready?
Mayor, let's move to discussion. First, and prior discussions, we have for you a draft of an ordinance that's subject to your consideration and further instruction to staff. Could be used to initiate a charter amendment election. As we've made a lot out of over the last week, your charter is rapidly heading to its 100th anniversary birthday, whichever is the appropriate term for man and object. And over time, your charter has held and has held very well. In fact, it's one of the least amended charters, certainly for a city of this size. Nonetheless, as we have gone through time, while our charter has not changed, there are many things that have changed around us. State law, court cases, items that were covered in your city charter that were not originally covered in state law, which over time state law will catch up and they have their own. In those cases, your charter is in conflict with state law rules. So we have before you a draft with a series of potential propositions. Each proposition, if you did choose to push it forward to the ballot, would come on as a separate item, so a yes or no for each one. As this would be a charter amendment, certainly it's an election, a regular election in terms of showing up in November and going into the voting booth, you are required to consider it on 2 readings. So if this is an item you wish to push forward, you will need to have it for a first read next week, followed by a second reading thereafter.
Which is the last day.
Which is the last day. I think it's the last day in our meet every Tuesday schedule. Mayor, I don't know how you want to kick this off, but we can have Marcus just run us through if you would like, and then stop for.
I think there's so many things that are just, I don't know if perfunctory is the right word, but have to be changed to allow for what state law is. Those are really important to get done, and we've dealt with those in plenty of ways. I'd like Marcus to outline those first, and talk about what we really need to change these things.
Certainly, Mayor, thank you. And I've enjoyed the attorney-client exchange with you in closed session the last couple of weeks as I got your guidance and ready to produce this now publicly. And we can. There's still a couple of issues I think to be discussed in closed session today, so I get some more of your guidance on this as I prepare this ordinance. But the first proposition is just what you said, general terminology, just updating. There are a lot of inconsistencies in old terminology, as you would expect in a 100-year-old document compared to modern times. We no longer refer to Ms. Hibbs as the city clerk. She's the city secretary and has been referred to that since the mid-50s. You'll find actually both terms used in your charter, and that's just an example of inconsistent terminology. And one that may be of public interest, updating the name of this very body from city commission to city council. You know, the fourth estate, the news media often has, some of them have difficulty keeping it straight, whether it's the county commission or the city commission or the planning and zoning commission or the parks commission. Everybody's got the title. Commission was a very popular title in this area of the state apparently back in the turn of the last century. And so one of the changes in Proposition 1 would be to update and modernize your name and call you the city council and council members instead of commissioners. And hopefully that will help better distinguish different arms of government that we have here in the local area. Proposition 2 is
Wait
another.
a second, let me ask you a question right there, Ken, to take it a step further.
Yes, sir.
So my position or my title would be city councilman place forward,
Yes, sir.
and that's the way it would be identified on some future ballot, all 4 positions.
Yes, sir.
Okay.
Just change it from commission to council, and
That's going to be hard for us old heads to get used to.
I bet it'll come easier than you might think. We'll
Okay.
see.
Yeah, that will change it.
The second proposition is in this exact same vein there. We have some old clauses in the back of the charter that really only had any purpose during the years 1913 to 1915. And there were provisions, like you might imagine, if you've been doing city government without a charter, and now you want to put out to the voters to adopt a charter, there needed to be some transition clauses. If this passes, then in 1913 we're going to appoint these people. They'll serve until 1915, at which time we'll then be in our regular election cycle. Those clauses have meant nothing since 1916. It's just a housekeeping matter. It doesn't really harm anything other than the fact it's just more ink to have to print whenever someone wants a copy of the charter. So number 2 is also housekeeping. Number 3 is housekeeping. As the manager mentioned a while ago, we now have many more state laws on subjects than we had in 1913. In 1913, there was almost no Texas law on annexation. And so there are very lengthy provisions in your charter, requirements, procedures, and they actually conflict with current state law. So we would like to bring that into alignment with current state law. Proposition 4, again, same thing. Once upon a time, cities, home rule cities could decide to do an election any day they wanted to. Pick a date, publish a notice. Those days are gone. Austin controls much of what we do. And elections, they strictly mandate when you can, what days of the year. Let me just remind you, out of 365 days every year, there are but 2 days that you may have an election. Period. End of discussion. State law has far eclipsed your charter. So Proposition 4 would take all the different references in the charter that talk about dates for elections and timing of elections and simply say they shall conform to Texas Election Code. It is highly prescriptive now. Proposition 5 is another flavor, and the next verse of that. Your charter currently says your city elections shall be the first Saturday in April. Folks, we haven't been allowed to have an election in April since before I came to work here, which is what makes reading the charter so cumbersome. Someone reads the charter and says, well, it says first Saturday in April. Well, we're sorry. We haven't amended our ordinance, our charter. State law says the spring election is in May. Texas Election Code trumps our charter. We'd like to clean up that confusion and stipulate that your regular city election will occur on the state allowed date, the nearest to May 1st. And that gives us a little flexibility for whatever the legislature does to you in future years without having to come back and amend this too soon. Proposition 6, apparently $250 was a whole lot of money in 1913. The city manager today can spend up to $50,000 on routine items, and certainly he can do that during an emergency when we have wildfires or tornadoes, blizzards, and we have immediate overtime. We need to provide food for crews working overtime, maybe rental equipment. That's all done under other statutory authority, and we want to clean up our charter and take out the $250 limit because those spending authorizations are set by other law today. Proposition 7 and 8 we'll discuss with you further in a moment. Proposition 9, on initiative and referendum petitions, the right of initiative and referendum exists because of your charter. It gives that right. And Proposition 9 would set a time limit by which the initiative or referendum committee must get their petitions signed and get them back, so that issues do not drag on endlessly or confusion enters the process, as we had our recent experience with when the petition was out, and it was out for so long you had another city election. There were issues we resolved, we addressed them, but if we can prevent issues in the future, we think that's more efficient and better government. And if it's a really hot community issue, 90 days is not unreasonable to go out and get your signatures and turn them in. Proposition 9 would state that signed petitions are not returned within 90 days, and they're deemed to be withdrawn. If the committee lost interest or the community is not interested.
And it's currently 180.
And it's currently open, endless.
The 180 state.
The 180,
180
the
state
100,
law.
the 180-day rule that everyone is quick to jump to is really a very narrow rule. All it says is that the signatures on a petition expire after 180 days. Well, as long as you're gathering more signatures and are expiring, you can keep your petition going, you see?
Some dropping off on one end.
Some dropping off and adding to the other. And so that pushes you out 7, 8, 9, 10 months. How long do you want to keep on the treadmill? And so, as some other cities have done, we've studied the charters in other Texas cities. Some of them have 90 days, some of them have 120 days, some of them have 100 days. You're right there in the range with some other cities. So how does that clarify?
Yes, sir.
Commissioner?
Thank you.
Proposition 10. Right now, the charter is open-ended in terms of the time allowed for the city secretary to validate signatures. We have our prior city secretary and our current city secretary are women of integrity and very intentional and very deliberate in getting right to those petitions and working on them diligently. But with our growing population, the growing number of registered voters, those signature requirements are creeping up since 1913. The 1913 charter has no timeline. We think it's good due process, it's good government to set some timeline, because you might not always have a city secretary who's so diligent and of integrity. And so we would set the proposition as drafted to give 21 calendar days, 3 weeks to get that done and let you know the status of that petition.
We also want to encourage more voters, and with 104,000 registered voters, if 40,000 showed up, it would be very cumbersome to do that in a number of days, because then that number automatically goes up in the current.
That's a good point, Mayor, and I guess if you wanted to put some sort of sliding scale, should be 21 calendar days and then 1 additional day for every 4,000, 5,000 voters. We can make it more sophisticated, but we were trying to just...
I think this is the right way to do it, though. I think this
And you
gives
know,
them leeway.
20, 30 years from now, if we've grown and we have those huge numbers, it'll be up to the city leaders then to come back and amend the charter and boost it up to 25 days or something.
Well, but even on these last 2 petitions, did not Frances have to get extra help to validate those signatures?
She did.
So if you have done something like what you're saying, they get extra help.
Well, she used extra help, and they worked extra hours. They worked weekends and evenings. They worked hard at it.
Should it be working days rather than calendar?
That was debated. We discussed calendar days and different numbers, calendar versus working.
I think for where we are now, where we're a city, we're likely to grow over the next 5 to 10 years. This is likely sufficient.
21 calendar.
Proposition 11 is a situation that our charter is silent on. Other cities have encountered a very difficult problem, and that is what happened. Well, when you have repetitious petitions, you have a petition, it goes to a vote, the city incurs that cost of an election. There's always a winner and a loser in an election, and for the voters to turn down an initiative, many cities have found it's good government not to allow that topic to come back for a vote for a few years. Let it lie. Let people have time to think about it, so that you don't immediately turn right around, have a new petition filed the next Monday morning, and the following election day you're having another vote on the same topic the voters just turned down. We have had a couple of repeat initiatives here in Amarillo in the last 13 years, but it was self-policing. In both of those cases, there were a couple of years between those smoking and same number of districts on 2 topics that had come up, gone to the ballot box twice, both times, both issues defeated. But this would place in your charter a 3-year cooling off period before that same topic to be brought back.
What is a ballpark typical cost of an election for a referendum like this?
$30,000 to $40,000, I believe is the number. Is that our budget?
Yes. Historically, till the most recent, they ran, I want to say 28.
So approximately 30,000.
Proposition 12 is the one that I started saying it can be such a difficult problem to deal with that we have not had in Amarillo, and other cities have faced it. And that is, what do you do when voters approve? Let's take 12 and 13 together. What do you do when voters approve of conflicting propositions? Whether they're charter amendments or whether it's an initiative or referendum. One does a petition drive to declare the world red, and one does a petition drive to declare the world blue, and they both get a majority vote. You go in and vote, and you pull the lever for the red, and you pull the lever for the blue. Which one becomes the law? Well, Propositions 12 and 13 would say that whichever one conflicting measures receive the most total votes would prevail. And I hope that's not perceived as looking for a problem that doesn't exist. I think we've just been very fortunate. But we're seeing. Huh?
It has happened?
It has happened, San Antonio and Austin.
Okay.
And they now have these charter provisions that tell you what do you do when you have Proposition 1 passes, Proposition 2 passes, and there's no way to reconcile them. Which one becomes your law? And by charter, it says the one that got the most total yes votes. And so it's a tiebreaker. These are both tiebreakers for two different situations. Proposition 14 is another cleanup. We have several places in our charter where it mentions a specific state law by chapter and verse. And guess what? They don't even have the book anymore. It's gone. It's been rewritten in a different part of Texas law. So now your charter refers to a non-existent state law. Well, a law has been moved somewhere else. We want to take all of those specific references out and just simply say applicable state law. And wherever the legislature wants to move it, we don't have to worry about our charter then being out of step. Proposition 15, it sets a maximum municipal court fine of $200. Texas Constitution and Texas statutes set a fine of up to $2,000 in municipal court for certain offenses. Again, your 1913 charter simply has not kept pace with the evolution of Texas law. We recommend removal of the $200 reference in the charter. It just confuses people. We have defendants show up all the time saying how, you're illegal, you're violating the charter. And we have to stop and do a civics lesson that no, your charter's just way out of date. State law now provides this. Here's the current side. And it just will help avoid arguments and misunderstandings from well-intentioned citizens. Proposition 16, likewise, the charter in 1913 says there shall be a city judge. Well, you've had several judges for a number of years, and the way we've done that is the same way the U.S. Congress did it. You have constitutional courts and you have statutory courts, where we've had charter judge and ordinance appointed judges. We simply bring unity back into that, one source of appointment, one source of authority, by taking the number out of the charter and just simply says the governing body appoint the necessary number of city judges to do the job. Proposition 17, great foresight in 1913. The concept of open and closed meetings was known back then, but we didn't have the Open Meetings Act of Texas until the 70s. We would again, this law is so important, we would request that the voters would insert a reference to the Texas Open Meetings Act. It is the cornerstone act that regulates your meetings. Proposition 18, another cleanup.
Question, Counselor.
Yes, sir.
And this would apply to several of these that's probably gone over. Let's say that they're defeated.
Well,
We still have to comply with state law.
We still have to do it.
Even though the voter said, no, you don't.
We'll still have to do it. We'll just continue to limp with one foot in the street and one on the curb.
Yeah.
Until we have another opportunity to try to do it again.
There'd be one car on the street and one on the curb.
I appreciate that.
On
You'd
the
have to be here
sidewalk.
all
On
day.
the sidewalk.
You'd have to understand that, you'd have to been here all day. So
It simply means that in Amarillo, to know what the law is, you gotta have the charter in one hand and state law in the other hand. If you're gonna
State
really
law always rules.
read them together.
May I ask a question on that?
Yes, ma'am.
There is no place where the city can trump state law.
Not unless state law says, and sometimes you'll read it, it says unless otherwise provided by charter. Occasionally, state law, we
They
go
allow
by
it.
charter.
Those
They
are-
allow
But
it.
when they
Those are
set
fewer
the
and
law
fewer.
down, we have to follow that law.
They do, Mary, and that rule you just stated comes right out of the Texas Constitution, the highest authority in our state. The Home Rule Amendment to the Texas Constitution, when the voters approved back in 1912, that yes, we can have home rule charters. Article 11, Section 5 says that we can have home rule charters and home rule government, provided that no provision of a charter shall be contrary to general law of the Constitution.
And when state law changes,
We should change our charter, or we should be wiser in how we write our charter.
so we don't have to each time. That's what you tried to incorporate.
And with due deference to our forefathers, in 1913, the home rule charter movement was so new in the United States, no one was quite sure what you needed in a charter. And out of an abundance of caution, there was lots of detail written in that today is covered by general law of the state.
Thank you.
You're welcome, Mayor. Proposition 18, the charter is actually self-contradictory in one way. The charter defines a quorum of this body as being a majority of all members elected on the commission. Well, that sounds pretty good till you read the rest of the charter, and it says if there's a vacancy, you can appoint a member. Now go back to your quorum. What was a quorum? Elected members. It doesn't allow for counting an appointed member as being present for a quorum. Maybe that's a detail only a lawyer can love, but we're recommending that we take out the word elected.
Why in your proposition do you refer to this as all members of the city commission, city
Because
council?
Because until it changes, the voters haven't changed their name yet. I have to go by current law.
Yeah, that's, I asked the
But,
same question.
but that will be, that's already on our checklist. If that proposition, if this goes to the ballot and the voters approve the name change, then each of these others, we will conform that name.
And you can do
Council.
that.
Yes.
You can do that without going back for a vote.
Yeah. Good question. Proposition 19, we're almost at the end.
Could you come up with a charter amendment that says, that speaks to the future, that we have to comply, that regardless of what this charter says, we must comply with state law. Therefore, when a law is passed, the state law is passed,
It already says that, the Constitution tells us that our charter cannot be contrary.
the state constitution
The
says
state
that.
constitution says that, and the problem is our 1913 charter has too many specific statutory references and language.
You're looking for a self-amending.
Right,
Yeah.
right, and we
You
can't,
can't-
a charter can only be
you can't do
amended
that.
by a vote of the people.
Yeah.
Yeah, that's another part of that constitutional provision.
I guess Jim could say it's like deja vu all over.
This is basically the state lays down the law.
Yeah.
I'm just trying to make it simple.
Um,
You're in the wrong place.
Proposition 19 cuts you no slack on your weekly meetings. The charter says the city commission shall meet at least once each week, period, end of discussion. As you saw this past winter, occasionally Christmas falls on a Tuesday, which means New Year's also falls on a Tuesday. And as you saw, blizzards are no respecter of the calendar. And when you get however many inches on Monday night, come Tuesday, nobody's getting out. And so Proposition 19 would simply provide a little leeway to say that would allow cancellation of a meeting of the city commission for exigent circumstances, provided that no event shall such a cancellation result in less than 2 meetings occurring during a month in the absence of a disaster declaration. We still have to have a little wiggle room there. So you just take this past year as a great example. Tuesday, you would have canceled a meeting for Christmas. The following week, you would have canceled that Tuesday meeting for New Year's. Well, that puts you into the second week of January. You know it can snow around here. Well, what if we had a disaster declaration
Well,
shutting down the city? You could miss 3 weeks in a row, is what I'm saying. It would be remote, but it's possible.
Well, you could have had to cancel the first 2 meetings in December, and then all of a sudden here comes Christmas and New Year's following.
You could do it that way.
Golden opportunity.
Yeah, there's not a perfect answer. We were trying to allow some flexibility for exigent circumstances without setting up a situation where some official could just on a whim cancel meetings and hold paralyzed city government.
And nowhere does it say that it has to be on a Tuesday either.
That's correct. That is set by ordinance right now. And so that's easy for you to change. And the ordinance says it shall be on Tuesday or is otherwise directed by the city commission. So you don't even have to amend your ordinance if you want to change the day. That's another topic. Proposition 20, election eligibility. This would be a major change if it is approved. Currently, a person who meets state law requirements and the residency requirements of the charter is thereby eligible to run for the office of mayor or city commissioner. While there's some virtue to basically letting any person, any resident of the city run, history has shown there can be some abuses there. Of what one might view as an abuse. It forces taxpayers to pay the cost of an election when elections might have been canceled, but for this opposing candidate, someone who has no intention of running for office actually, running a campaign, no intention of serving if elected, no anticipation of winning or trying to win, and we're required to have that cost of an election. What we discovered in our recent election is staff then has to work with all these candidates, and you have this candidate who refuses to cooperate, completing forms. I was on the verge of having to contact some state officials to initiate enforcement action when one candidate finally begrudgingly cooperated with staff. We spent time and money, taxpayer money was spent dealing with a person who was going to not conduct a campaign and had no intention to serve. So, and it leads to longer ballots for these nominal candidates. Proposition 20, if it were to be approved, would state that a person desiring to file as a candidate for mayor or city commissioner, the candidate shall, in addition to all other requirements and qualifications, either pay an application fee of $100 to the city secretary or in lieu of such fee, submit a petition signed by 100 registered voters of the city supporting the person's candidacy. This is not unusual if you look at other Texas charters. Again, we've been very content to sit on ours for 106 years, 100 years. Other cities have admitted theirs more in modern times. They've experienced the same challenge with nominal candidates. And so they require the $100 to help offset the cost of staff time on those elections, administering them, and as a poverty provision, so we don't keep anyone from running who wants to, they can submit the signatures.
I think with a cost of an election at this point being $30,000, I think 100 is too low.
I don't. I debated this in my mind, just my decision after we had a discussion. 100 signatures or $100. You know, if I think of the 22 candidates in the first election that I was involved in for mayor, and then of the last election, I think it makes them think twice when they just come and sign a piece of paper and say, I'm running.
My question is not whether 100 is too low or too high, but why, if there's a way we can not put a number in and have it determined some other way, because in 10 years or 20 years, 100 will be a whole different number than it is now.
Good point, Commissioner. And there's really, it's your option, it's y'all's choice. There's 2 points of view on that. One is we can change that to say an application fee or number of signatures set by ordinance, and as you suggest, that can be changed. The other point of view on that is this is a fundamental requirement for office. It ought to be clearly stated in the charter and let those future generations fend for themselves. Hopefully it won't be another 100 years before there's an update to the charter. those are the two competing viewpoints on that it ought not to be easily changed. What if you had, again, a majority on the city commission sometime who were not persons of integrity? Elections were coming in May, and so in about February, they passed an ordinance that said it's a $10,000 filing fee, because they can all afford that, or 10,000 signatures. Well, you don't have 5,000 people turning out to vote some years. That would be the concern, by letting it be too easily changed by the governing body who are themselves elected.
Commissioner,
I would encourage you to consider stating the number, whatever the number is in the charter, but you are correct, there is an alternative path.
Commissioner, I don't disagree with the logic of what you're saying. But one of the things that struck me is that to this point, everything that we've had discussion from Mr. Norris about, they're really not controversial. They're things that make sense to do, common and horse sense to do, to meet state law. I would like this to be not as contentious. This seems not as contentious, and it seems like it does add some value to some of the files. I mean, but it isn't too, it could never be considered severe, I don't think. And so,
Anybody ought to be able to gather 250 signatures.
well,
If they're a serious candidate, they want us to spend $30,000 for an election, they ought to be able to gather 250 signatures.
or do $250. I mean,
Yes.
if you want it either or.
Yeah.
I'd keep it a lower number.
You think that's high? 250 signatures for somebody who wants
I do.
to spend that much
200.
money?
I want to make sure, no, I think
Don't
that's
exclude
fine. I want to make
anybody.
sure
Yeah.
everybody can run that
Don't
wants to
exclude
run.
anyone. I mean,
That's
I don't.
serious about campaigning.
Yeah,
That's
my,
right.
my concern was, you know, some people who may want to run, who have very modest means, et cetera, they could still do this. If we raise the bar too high, then we're sort of,
Elite.
yeah.
You think 250 signatures is too much to ask of somebody?
I do, in some
Yeah.
cases, when
Some
we've had
cases.
commissioner votes that have been basically that, for county commissioners in sections. So I don't want to exclude a section, an area that might have more difficulty raising petitions and interest than other areas. I'd like everybody to be able to participate, but not just whimsically. And I think this
Yeah.
accomplishes that.
I even had to look at this whole idea, and then when I started looking at every place else and what they do and other offices, and I thought, oh, okay, well, I can see the validity of doing something like this, as long as it's not too, the bar's not too high.
I don't want it to be too high, and that goes in my thought with, I don't see, well, so far, what we've discussed, I see so little controversy in just dealing with something that's pretty much a need that state law requires. State doesn't require this. We're getting into things that are a little more questionable, but to me,
Of course, in
This is
Dr.
pretty
Eads, I
easy,
think we have
yes.
had some candidates that couldn't get 100 signatures.
it wouldn't go work to do it. Not
That's
just couldn't, but
that's
wouldn't
what I
do
worry
the
about,
work.
is when you've got one person who runs, and that's the reason why you've got to have an election.
Well, we're never gonna get rid of that if they have.
And they can't even get 250 signatures. It's like,
I would think they'd get 100.
I don't think they'd get 100.
Well-
I mean,
I think
the
100
filings
registered
come at the
voters is
last
a lot.
minute. They aren't done with preparation. They say they aren't gonna run. I mean, we don't wanna exclude someone that really wants to run, even if they don't know what all it takes.
And it's not just 100 people, it's 100 registered voters.
You can't beat Ben Gump. It's gotta be Ben Gump, city
Well,
It's
resident.
not intended to exclude anyone, it's intended to seek candidates who want something more than just their 15 minutes of fame. They're willing to exert some effort or put some nominal sum of money on the table. And maybe that'll motivate them to participate fully.
Does it need some clause in there of the city secretary verify?
Yeah,
It will.
I
Yeah,
asked
I
that.
think,
Well,
We talked about that.
it would require,
Do we
it
need
would
that
have
in
to be
there?
verified.
It needs
someone's
They
gonna
have
have
to
to
be
find out
verified.
if they're, I mean, you could say signed by 100 registered voters as verified by the city secretary.
Okay.
Yeah.
well, $100 is a pretty cheap price for 15 minutes of fame. So
Well, but I don't
I'm
think we're ever
obviously not going to win this argument.
But 250, Commissioner, would be the same thing. If you had somebody that really wanted to stir something up, it's not too hard to get 250 together with 5 or 6 people. So I don't think you're gonna stop that. All I don't wanna have is people that are just not serious at all. Just not serious at all cause an election.
Because they're not gonna want to pay the $100
No.
anyway.
I think it's a good idea to get the 100 signatures, even if you have the $100.
Well, I think it
Because you
needs-
go around and tell people you're running for
Needs to be an
office.
either or though,
Yeah.
in my mind.
Yeah, me too, I'm just saying. might benefit.
Well, they're silly not to. They're never gonna win if they don't go get 100 supporters at least that would sign
Yeah.
something. And if you give them money, it's even more support.
Be tough on me, I mean, and tire my pallbearers.
No doubt.
Proposition 21. The charter requires that the city manager and certain other officials, some of whom no longer even exist, post a bond of $5,000. Again, at any given moment, the manager can spend $50,000. This has not kept pace with the current economies. Proposition 21 would take out the $5,000 and say that bonds of the city manager and other employees may be will be set by ordinance. Takes Commissioner Green's idea, we use it on the next proposition, and that can be adjusted based on the person's level of spending authority. Proposition 22, the last one we have here, is we have policemen and firemen have civil service. The voters of Amarillo in 1944-45, at the end of World War II, adopted civil service for returning soldiers and civilian employees, and we've had that ever since. A form of civilian civil service. The charter currently exempts certain people from civil service protection. It says that the city commissioners and mayor are not under civil service. It says the city manager, city secretary, city judges, city attorney are not under civil service, division directors, department heads. What this would do is be to extend that list a little bit further to exclude some other employees for civil service. They would become purely at will employees. And the ones that would add to would be assistant city attorneys and those whose services would be licensed and regulated under the State Professional Services Procurement Act. Who is that? That would be such persons as nurses, physicians, accountants, architects, surveyors, engineers. Those persons on city staff who hold those kinds of professional credentials would no longer be under civil service. So if it came to terminate one of them or deal with one of them on personnel issues, it's done more directly, and that basically means an employee. This has been an issue in our organization. I've had some issues in the past on two different occasions when terminating the employment of an attorney, and on two different occasions the person's tried to invoke civil service. I had recourse through the State Bar of Texas through an ethics disciplinary process. You, the client, if you no longer desire the services of an attorney, you may release that attorney at any time, and their only duty is to say, yes ma'am, yes sir, and turn over the file. If you don't do that, you can lose your law license. And so we were able to deal with that one, but it just ought not to be an issue. And we do have these other professionals. I can't speak to their individual claims. That is as I determine your consensus from meeting with you, that's the draft. There are a couple of propositions at the very end that we've appended that we can discuss now in closed session. There really wasn't a clear consensus, so we kind of carved those out for a separate consideration. Closed.
Well, the others, I think.
You can discuss it openly if
If
you've got legal questions, we can go into closed session. If you want to just discuss it from a political and policy standpoint, that's open session discussion.
Because these were somewhat contentious with this commission, I think that if we get into legal questions, we can save that. But I don't mind us openly talking about
Okay.
these things.
Proposition 7 is the one that would allow electronic notices. In 1913, people got all of their news and notices out of the local newspaper. That is not the case today. The newspaper circulations are down. As you know, newspapers themselves are now resorting to the internet. The days of having the paper in the front yard are numbered.
I still get mine on there.
I get mine on the front steps.
The legislature is beginning. Okay. these last two, however long you want to call them. The legislature is beginning to slowly allow cities to post more and more things on websites. And this would, your charter still requires newspaper publication. If you want to, Proposition 7 would allow the possibility of internet posting. Of course, the newspapers oppose this type of legislation, whether it's in your charter or whether it's introduced in Austin at the legislature.
It is a cost-saving measure is about the primary reason we consider changing it.
And it's also a notice, Mayor, I would submit that more people get their news off the internet now than they do picking up the newspaper out of the front yard. At least if they're under age 30. Yeah. If you're really trying to get the word out to people, there's an argument to be made that, well, you put it on the internet, put it on your Facebook, your website.
Well, these two were, we talked about these and how they work. And one of the things I've come back to in my own mind last night and today is that these are left to the voters, they'll decide, just like the rest of these. These are left to the voters, they can settle this debate. We aren't trying to speak for the voters, we're trying to get the issues out to the voters. So I don't know. I mean, I don't know how I feel about it.
Well, we are in the digital age, I mean, and if the state's moving towards that direction and allowing that to happen, I'm sure that at some point in time they're going to say that's what we have to do. So,
Well,
I mean, we can't fight the tide.
I don't know that they'd say you have to, but they've said now you have the option to, right?
Well, now they require both most of the times.
They
You
do?
shall publish it and you shall put it on your website.
Really?
Yeah, but the day's coming when they'll drop, I think they'll drop the publishing.
So we still will use the newspaper to a degree when the state requires it.
Where state law
And
requires
that's
it.
what it says.
Again, state law.
Unless,
But there's many things that are controlled here locally. Your charter says you have to publish it in the paper.
One of the things that concerns me, and maybe this isn't proper, but it sure concerns me, is to me, the primary voters are the people that still get the newspaper. People that go out and vote get the newspaper, like me and Jim and a few others that go pick it up in the morning. And I'm serious. I mean, those are voters.
Some of you younger people.
Those are voters.
What's a newspaper? I'm joking.
Propositions,
Don't quote me.
that's a good point, Mayor, the generational differences. Our society is in some transition, we're in a transition generation. This is written permissively of May.
So we could put it in we could decide on an issue to put it in the newspaper or not.
Yes.
Even though this was there, we could do that.
Well, it says that
May.
it would say that an ordinance or resolution may be posted electronically as an alternative to publishing in a newspaper unless newspaper publication is otherwise required by law.
My analogy of being in the television business is that we have different formats, and I give I give 2 or 3 different formats depending on what you want and how old you are usually. You know, I gave Wells Madden a few years ago a DVD, and he said, "Do I put this on a turntable?" I said, "Wait a minute." And I came back and gave him another format, you know, without even asking. So it was just, you know, it's just like that. So
Point made.
yeah, and so even if this passes, I would say we need to reach as many people as possible, and we need to publish it in several different ways, in several different places.
But we do,
But,
for instance, with our elections, certainly when I was looking at things, I looked at lots of different ways to get the message
yeah,
out.
exactly, when you're
Certainly
marketing.
fair.
I think this proposition needs to be on the ballot.
Yeah, I do too.
And then we can do as a.
Then the voters can
city vote.
decide. On an individual
So can
basis,
we.
we can decide.
So can we,
That's
we
right.
can do May.
Proposition 8 has to do with the number of signatures required on an issue from referendum, whether you want to put forward a proposition that would change that. Currently, the measure of signatures is 25% of the votes cast in the last city election. Various cities, there's tremendous variety. Many cities, there are lots of choices. We've listed some suggestions for you. You could just simply increase the percentage if you wanted to from 25 to 30% of voters in the last city election, or 35. That was the highest I saw in the other city. Some base it on the number of total registered voters in the city, for example, 5%. So we leave that for you if you want to leave it as it is, or if you want to change that.
What brought this topic up was when people actually stated they were trying to lower the number of voters to be able to manipulate afterwards the petition process. that is just totally
Un-American.
undemocratic to me. And so that brought the subject up. Now, you know, again, on the issue of controversy and having some pretty straightforward things here to go with and people to decide, maybe you put this on a ballot, just let them decide, and maybe it isn't that important. If you took the 5% number, our registered voters are somewhere around 100,000 now.
I have the exact numbers.
Please.
If you use 5% of registered voters, that would be 4,933 signatures required.
And how many were required under the last election prior to this one to do a petition? Under the last one.
Something over that number. If you went with 7% of registered voters, that would push it up to 6,906. And just, I thought this was curious, if you put forward, the voters adopt the 90-day rule, that if you have a petition, you got 90 days to gather your signatures. If you had 5% of the registered voters as the requirement, that's 4,933, that's 55 signatures a day, if that other provision were to pass. 55 signatures a day.
And how important is this? I mean, to me, it was flying in the face of democracy that somebody would try and manipulate an election count in order to take advantage of another thing written in our charter. If we have 104,000 registered voters in the town, to ask for to get petition on 5%, you can't manipulate an election number to do that. You're dealing with registered voters. To me, that has some appeal, but
I think if you can
overstating
get a
the
good
value?
percentage of people, 5% or whatever, to say we need to go to the polls, then we should go to the polls.
Absolutely.
But if the bar is so low that we're going to the polls over everything, then
Well,
that's not good for anybody.
What I don't like is the ability to try and stress, let's not have people vote so the bar will be lowered. That just flies in the face of any kind of democratic process. To
Well, but
me-
somebody can say that, but I don't believe a voter's gonna respond to that.
Well, it may have.
I'm gonna stay home because I wanna lower the bar so that I don't think many voters are gonna respond to that kind of thing.
Unfortunately, many voters don't respond to our elections.
They don't. But
7,400 or whatever. it
There,
was.
but on one hand now, we have kind of a mixed message here. Because we had the other issue a few minutes ago about the cost that you gotta pay, the signatures you gotta collect, because we don't wanna raise the bar. Yet, in this situation here, we're talking about raising the bar. Now, do we wanna raise the bar or don't we?
I want everyone to be able to run that wants to, and that's very serious about it, regardless of income. And yet I want enough people to say, yeah, we need to go to the polls, to make it legitimate to go to the polls, instead of going to the polls because you don't like the color of my pen.
And I don't want to say that we're raising the bar,
Yeah,
we're
25
stopping
people.
manipulation. My only reason to do this would be to stop somebody's ability to manipulate the election by saying, don't go vote. I could care less about raising the bar. In fact, what would it be if it was 4%? 4% may be adequate. If 4% wouldn't allow them to fool with the bar.
Marcus, isn't 5% what a lot of cities are doing? Isn't that kind of average?
Commissioner, I looked at 15 different city charters of cities our size and larger, and it's all over the board. Some have a flat number, like you must have 5,000 signatures. Some it's a percentage of registered voters. Some it's a percentage of voters in the last city election. There was one that was a percentage in the last gubernatorial election. I don't know why they would do that, but
Why would you do that?
I've got a chart on.
I don't know the percentage of registered.
The longest one I found, Grand Prairie had 40% of the voters in the last election was their threshold for an initiative or referendum, or 40% of those in the last election, or 15% of all registered voters.
I like the registered voters.
That's the
15% is
highest
awful
bar.
high.
That's
Well, the
highest
worst
bar.
thing that could happen with this, if you put it on the ballot and somebody rejects it, it stays the way it is. That's the worst that could happen.
I think 5% of the registered voters is wonderful.
Yeah, I do too. I think we ought to have enough people saying we need to go to polls, and then let's go to polls.
Because again, you got the $30,000 cost of election, if there is that.
Yeah, I think we stick with the 5.
If 5,000
Is that okay,
people say
Counselor?
no,
I can prepare that for next week's draft.
And I might add that when I was reviewing these charter amendments, we're doing it because we're going to celebrate 100 years of the charter, and because it's so outdated. This is the prime opportunity to really change other things, not just this or whatever. It was an approach to really update all our charters so we don't have to keep fighting the battle of, you know, the ordinance says this. And so this also needs to be changed in conjunction with the other changes.
Yeah, I think we should.
Thank y'all for that direction.
I'm gonna tell y'all, I think that's a mistake.
You do.
Well,
I really do.
I think it is, I think it falls into my concern about making this more of a controversial thing. But they're still, they're gonna vote on each individual item. Anyway.
You'll have, if I may, this will be back next week, it'll be on your agenda, you can have all these discussions
Okay.
again. We really feel pressed to get to closed session for some legal advice later before your meeting.
Okay, thank you. Very good review. Thank you for all your work on this.
Mayor and Commissioner, I'll call closed session pursuant to the following